Good morning, Judge Leon, for TOP A2378 on behalf of Mr. Von Hensley, Session.
What are you doing on this?
So, Your Honor.
All right, everyone. Buckle in, because this case turns tense fast. Today we're stepping into a courtroom where a simple plea deal spirals into confusion, hesitation, and a judge who clearly has zero patience for mixed answers. The defendant is facing assault and trespass charges, and the plea offer on the table could keep both charges off his record if he can give the judge straight answers. But as you're about to see, every time the judge tries to clarify, the defendant hesitates, backtracks, or contradicts himself, and that quickly turns a routine hearing into a full-blown verbal chess match. Watch closely, because some of these exchanges reveal just how complicated and stressful plea agreements can get.
I did have a chance to talk to the prosecutor. Mr. Von Hensley is going to plead as charged under 771.1.
It's assault or assault and battery. If he has, does he have, my gosh, Mr. Hensley, he show up? If he has any assaultive crime on here, I'm not going to take that. I want you to be aware. Okay? Does he have any? In assault or assault and battery dismiss, not once but twice. Okay. Is that what you want to do, Mr. Hensley? What's your name, ma'am?
Shalonda Heisman, interpreter, Your Honor.
Oh, you're
I
the
saw someone in the hallway, and I'm here today for the case. Would you like to handle him today? Is what I would.
Spanish?
Yes.
Perfect. Lisa, if he hasn't left, we could.
Yes, he's at the. I told him to wait for me.
Beautiful. Thank you. Thank you. Great. Okay. You understand what your lawyer has said? Okay. I'm sorry?
Yes, sir.
So she's telling you were going to plead as charged to assault or assault and battery. If you do that, I will take this under section 771.1. It is punishable by up to 500 fines, 93 days jail, costs, or all those. Do you understand that? Do you understand that?
Yes.
And I'll take it under section 771. If it's complying at the end of the specified term that I set, the case will be dismissed. You understand that?
Yes, sir.
Did you sign the advice of rights?
Yeah.
Did you read and understand the rights?
Yeah.
When you plead guilty, you'll be giving up all those rights, and there will not be a hearing or a trial of any kind. Do you understand that?
Yeah.
So he's going to plead on both?
Yes, Your Honor.
So he's going to plead to both trespass and assault or assault and battery, right? Yes?
Yes.
And if you plead on the trespass, it's punishable by up to 30 days jail, fines, $250, costs, or all those. Do you understand that?
I wasn't aware of that.
Yes. Mr. Hensley, hang on. Just slow down.
Okay.
Yeah. You don't have to do this if you don't want. We can go to trial. You got one set for next week. I don't have a problem. If you plead with the assault or assault and battery, the possible penalties are up to 500 and fines, 93 days jail, costs, or all those. If you plead on the trespass, that's punishable by up to 250 fines, 30 days jail, costs, or all those. I'll take both of those under 771.1. That was the offer, right?
That was the offer, Your Honor.
You understand that?
Just the probation. Yes, sir.
I don't know what you mean by that, sir. There's no. I don't know what you mean. I don't know what you mean by that. You understand what the possible penalties are? I have to tell you the possible penalties. If you don't want to plead guilty, you don't have to plead guilty. It seems like it's a fair deal to me, but I don't know. And you don't have to do it. If you don't want to do it, don't think you're guilty of either one of those, that's fine. We'll go to trial. I could care. Doesn't matter.
I plead.
But let's go one step at a time. Do you understand everything that I have said here today? Mr. Hensley, I'm going to put you at the back of the call here real quick, okay? I'm not going to play games with you.
Yes.
If you're not understanding something, tell me. If you understand it, tell me. If you don't, tell me, but I'm not going to go through this little cat and mouse where you want me to.
Understand. So,
Okay. Did you sign the advice of rights?
yes, I
Did you
do.
read it and understand it?
Yes.
If you plead guilty, you're giving up all those rights, and there will not be a trial. Do you understand that?
Yes.
If you plead guilty to these, I'm going to place you on probation for sure. I don't know what other penalties there will be, but you will be on probation because it's under 771.1, and you'll have the opportunity to keep both of these off your record if you comply with probation. Do you understand me?
Yes.
All right. Any questions before we go?
Here's where the whole situation starts slipping out of control. The judge is trying to get simple yes or no answers, but the defendant keeps bouncing between uncertainty and partial agreement. In legal terms, this is a huge issue. A guilty plea must be knowing, voluntary, and unequivocal. If the defendant can't confirm basic facts, the judge risks accepting an invalid plea, which could later be overturned. You can also feel the judge's tone shifting, firm, frustrated, and trying to regain order. This is a common moment in court where judges must decide, do they keep trying to clarify, or do they shut the whole thing down and send it to trial? Let me know in the comments. At this point, would you continue the plea or move it straight to trial?
No, sir.
To the charge of assault or assault and battery, how do you plead?
Possible.
Guilty.
Guilty.
To the charge trespass, how do you plead?
Guilty.
Were you at Guardian Car Care on July 16, 25 at 18720 West Road in the city of Woodhaven?
Yes, sir.
Did you go on the property of Guardian Car Care?
Yes.
And had you been forbidden to do so by the owner, Michael Powers, prior to going on there on July 16 to 25? Did he tell you you couldn't go there before you went?
I wasn't aware of that. He never told me that. But okay. If he did, he did.
I don't know if he did. I wasn't there.
I wasn't aware of it, but if he said it, he said it.
I can tell. I should just set this for trial, shouldn't I? Because he doesn't want to plead. That's fine.
Frankly,
Sir.
I was there.
Sir.
Yes, sir.
I got a bunch of people wait. I don't like the people wait. I'm going to go slow enough to do what I need to do, but I'm not going to go back and forth with you. If you don't think you did anything wrong, by all means go to trial. This is the United States of America. But don't say, I don't know. If he says I did, I did. He did. And if he didn't, he didn't. And I don't remember him telling me. And that's okay. If that's the truth, we'll just go to trial. That's fine. Is that what you want to do?
No, sir.
I'm going to ask you direct questions now. And I want a direct response now. Did this gentleman, the owner of Guardian Car Care, prior to the offense date of July 16, 25, tell you were not to go back to Guardian Car Care at 18720 West Road in Woodhaven? Yes or no?
Yes.
Are you sure?
I'm sure. I'm pretty sure I am. Yes. Okay, he did. I'm sorry.
Are you trying to agitate me?
No, sir. No, sir. I'm nervous.
Nervous? I'm nervous.
I've got,
What are you nervous about? There's nothing to be nervous about. You either want to plead or you don't want to plead. We've been going back and forth. This case was arraigned back in July. This has got to be one of the longest cases on my docket where people actually showed up, although you did have a miss or two, a couple of them.
I'm sorry.
Just tell me, did he, if you don't know that he trespassed you from the property prior to the offense date, just tell me that. Did he trespass you, tell you not to go on the Guardian Car Care property prior to July 16th of 25, which is the date of this offense?
He may have told me. I don't remember.
Okay, well then I just can't take the plea. I'm sorry. We'll go ahead with trial next week.
Okay.
And, I just,
Yeah, I'm sorry. He did tell me that.
you think I want to play this game with you?
No, sir.
Do you think I look like, look at me. I don't have time for games. I don't have time for games. I'll give you all the time you need to be heard, but don't play games with me, please. You don't have to do anything today. You can say, Judge, I want to go to trial. That's fine. If that's what you want to do. But when I tell you repeatedly, I'm going to ask you a question, I want a straight answer, and you're vacillating. I don't know if that's what he said. Maybe I did. Maybe he didn't. I don't remember. And now you're saying no, and then you're saying yes, and I don't know what to think. You got my head spinning over here. I'm gonna ask you one more time. And again, if he didn't tell you that before that, just tell me that. It's fine. Did he trespass you from that property prior to July 16, 25, when they think that you entered the property?
I did not hear Mike Powell's mouth. Tell him.
Good enough. Good enough. We're gonna go to the bench trial. Will remain bench trial at 1 p.m. next Tuesday, okay? And you can go down the hall and get your new date, and you're all set. And I wish you well. Good luck. Not your new date, your old date. Paris, Arsland.
And that's where the judge finally draws the line. After multiple conflicting answers about whether he was trespassed from the property, the judge makes the only legally correct decision. He refuses to accept the plea and sets the case. For a bench trial, this is a powerful reminder that plea deals rely completely on clarity and consistency. A judge can't accept a guilty plea unless the defendant confirms the key facts without hesitation. In this case, the back and forth was just too confusing, and the judge wasn't willing to risk an invalid plea. If you found this case as surprising and intense as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.